Red X, sir. State your name.
Okay, one.
Sir, can you state your name?
Okay, 1, 2.
Sir, where do you live?
I live in the United States of America. Do you understand? Can I take a step forward or a step back?
You just stay right where you're at, sir.
Yes, sir. The United States of America.
Do you know what county you live in?
Yes, sir.
What county?
One of the 50. One of the 50 counties. Understood?
Is there a prior record on Mr. Epperson?
Has a battery in 23.
I have a battery. Understood? Just one.
Okay.
Mr. Epperson, you're before the court today on a burglary of a structure. That's a third-degree felony, punished with the 5 years in the Florida Department of Corrections.
I don't know what that means, sir.
Yes, sir.
50-50. That's what I understand. 50-50, white and black, E485. Understood?
I'm gonna, yes, sir.
I'm not trying to cause around.
I'm gonna appoint the Office of Public Defender to represent you, Mr. Griffith. I guess you need to
I
get
will
in
not
touch.
prove an advantage over you on the chessboard. I hope you know that.
Yes. I'm gonna set a $5,000 bond.
Yes, sir.
Next court date, July 7th at 9 o'clock.
Yes, sir.
No, his mother called the clerk's
Yes,
office.
A1, A1, AI. Understood?
All right, you can step out for me.
Police need from custody.
Next. Rimmer, come on. Red X. State your name, sir.
Mr. Rimmer, he's before the court today already, this week already, hadn't he?
Yes, sir. It was like yesterday.
All right, I'm gonna set a $5,000 bond on each of these. You got 2 counts of burglary of a conveyance. Those are third-degree felonies, punished with 5 years in Florida Department of Corrections, and a $5,000 fine. I'm gonna set a $5,000 bond on each of those. You also have a theft. That's the first-degree misdemeanor. I'm gonna set a $1,000 bond on that. Your next court date is July 21st at 9 o'clock. Good luck.
Step to your right to the T. When the green light comes on, you'll sign for your copy. It's fine.
Yeah, there's a lady that comes up here in a second. Listen to her charges.
Step to your right for me.
Found there's probable cause for your arrest.
She's gonna give you a copy. Step in on the Red X. State your name.
Ms. Beach, you're before the court today for your first appearance. Mr. Sell is present for you today. You've been charged with 1 count of principal to attempted homicide, I believe. Is that a first-degree felony?
Yes.
Punished for 30 years? Or life? Punished for 30 years in the Florida Department of Corrections. Judge Campbell reviewed the probable cause affidavit, found there's probable cause for your arrest. Ma'am, where do you live?
Here in Panama City,
How long have you lived in Bay County?
since October of last year.
Okay, where did you live at prior to that?
Mariana.
Okay, and are you working?
Yes, sir. I work at Gulf Coast Hospital and Dr. Memorial Hospital in Bonifay.
What do you do for a living?
I'm a phlebotomist and medical assistant.
I'm sorry, what?
Phlebotomist and medical assistant.
All right, and is there a prior record on this thing?
No, sir.
Mr. Sell, do you want to be heard?
Born and raised in America. Got a theft. 2 certifications. Pass.
Step to the T on your right. When the green light comes on,
Didn't anybody ever tell you how a courtroom works? Okay, in the criminal justice system, the people are represented by two separate yet equally important groups.
Dude, we've seen all the Law and Orders.
Oh, me too.
Questionable. And to top all this off, she has a weapon, and I feel totally vulnerable on set.
Hey everybody, while I fix this one here, we're gonna say hey to everybody. American Courts Live. I hadn't done it in so long, I almost forgot how. Thank you everybody for sticking around. We got a good little crowd tonight. We're going to jump into Thurston County. They got a good little protection order hearing. So here we go.
And so, Ms. Ringner, am I saying your name correctly, first of all?
Yes.
Okay. And then, Mr. Jackson, could you raise your right hand? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. And how is it you need an order against Ms. Ringner?
So back in, just give you background history, what's going on. I met her, I think, March, April, 2 years ago. At that time, me and Dallas was broken up and I met her. Subsequently, we began our relationship again. And I tried to break my relationship off with Miss Ringner. I told her I didn't want to talk to her anymore. Blocked her.
Wait a minute, say it again, please. A little bit louder. I missed that.
I told her I didn't want to talk to her anymore. I blocked her from calling my phone. I blocked her on social media. But one night she showed up at my house. She parked around the corner, crept through my backyard. I was in my home reading, and she tapped on the door, and I was, surprised that she was there. And she started telling me that she was pregnant, asked me if she can come in. And I said no, because she's making commotion on my backyard. But I'm a local realtor, so I don't want the noise, the confrontation. And I let her in. She spent the night. The next morning, she asked, "What are we gonna do?" I said, "Hey, you need to go your way. I'm gonna go mine." And at that time, she said no. I said, "What do you mean no?" And she said, "I'm not leaving." And I said, "Well, hey, it's 8 o'clock in the morning. I got to go to work. You got to go." And she's like, "No, I'm not leaving." So I tried to pull her out. She was hitting me and fighting me, wouldn't let me escort her out of my house. I also tried to pick her up and take her out. She's kicking, punching me, wouldn't leave my house. She called the police and said, "This man is putting his hands on me." I called the police as well. When they came, I told them my story. She told them theirs. I got arrested. Subsequently, the charges were dismissed. But also during that time, she came to my hearing the next day. Unbeknownst to me, she took pictures of me getting put in a police car. She took pictures of me in custody that day. She came and picked me up at the jail, and we kind of touched bases, but eventually we continued to see one another. Again, I tried to break the relationship off. Sometime in October, she showed up at my work, and because she couldn't text me or call me, she was emailing me that she's in my parking lot, and if I didn't come down, she was going to come up. Well, she stayed true to her word. She came up and started talking to me. I left my office and went outside because obviously I'm in a real estate office. I don't want to discuss my personal business up there. I went and I just decided to leave because it was just causing too much attention. She put herself in between my door and the car, so I couldn't close the door. Eventually I left, and I was working on the project, Your Honor. Sometimes I buy houses and flip them. I left the office and went to that project. I had no idea where she was at, but while I was in the house, just checking on the contractor's work, I heard some noise. She showed up there. I asked her to leave. She wouldn't leave. I was blocked in. And because of the previous situation that happened, I went across the street and told the neighbor, hey, I also recorded it. I told the neighbor, like, hey, there's someone here, and I just want you to be a witness to what's going on because it didn't work out the last time, right? And so couple months after that, we're hanging out again. Shannon had been drinking. I had not. We were driving back from her house. I mean, from South Tacoma way back to her house. And I was asking her about a conversation she was having with a gentleman inside one of the places we was at. And she just went berserk, started attacking me while I was driving, ripped out my contact out of my eye, scratched my face up. We almost crashed 3 different times. That night, I recorded her screaming and yelling. And then most recently, so there was a death in my family in Tennessee at the latter part of last month. And so prior to that, there have been confrontations. I know she takes anxiety medications. She also said she was taking weight loss medication. I have emails to support this that said it makes her irritable, mood swings or whatever. But because of the, her attacking me, all these accusations, I just told her like, hey, I don't want to, this is done and over with. I'm going to spend time with my family. My family's mourning right now. And I left. Between the 3rd and the 16th, I have not had any contact with her, but she has literally texted me 177 times. She can't call on my phone, and she can't get on my social media, but she's called me through WhatsApp 150 times. She sent me 20 emails, and inside these emails, she's threatening me. She's telling her kid's father, who's part of a motorcycle gang, what's going on, and she's having meetings with him. She's been to my house twice. She's reached out to my girlfriend multiple times. She's reached out to my girlfriend's kids. She's reached out to my friends. She's threatened to, call my mentors in the real estate world to supposedly take me down. She's posted things on Facebook of the arrest that I told you about, even though there's no conviction and the charges was dismissed. She posted that incident of me being arrested on TikTok and wrote this whole narrative that was just totally false. So I'm here because this needs to stop. I have not contacted her, and what she's doing right now, I feel very uncomfortable with what's going on. I mean, I know she takes anxiety medication. She blames it on her weight loss medication, but she's being completely irrational. And to top all this off, she has a weapon, and I feel totally vulnerable and unsafe.
Let me hear from her. And Ms. Ringner, could you?
All right. So far, who do you believe? Do you think it's him, or do you think it's her? Who do you think needs a restraining order, or do you think they deserve each other? Let's see where we go.
Raise your right hand, please. Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. What's your response to what I heard from Mr. Jackson?
So, Mr. Jackson, yes, we met back in 2023. I didn't know about Dallas. I didn't know about he was dating another woman long-term also. I didn't know about these women until a year and a half into our relationship. And that's when things started spiraling, is when the lady, Bridget, messaged me. And Ronnie happened to be sitting in my office. So to back it up, Ronnie is the one that comes to me. So he can sit here and say all of these things that he wants to. I leave Ronnie alone. Ronnie comes to my home. Ronnie comes to my office. Ronnie comes to where I'm at establishments with my friends. So it's quite opposite of what he's saying. So when he put his hands on me back in September, when he went to jail, yes, I went to his house, but he comes to my place all the time. So he can't say, well, you can't come to my house, but I'm only allowed to come to your house. We're in a relationship. So yeah, I was there. Yes, I was pregnant by Ronnie. He can sit here and spin the narrative all he wants to. I showed him the proof of all of that stuff. So from my chart, we talked, we got into an argument the next day, typical normal stuff with Ronnie, deflecting, doesn't want to have accountability for having multiple relationships with women and all of these things. And so he got frustrated and he grabbed me by my ankles, dragging me around. His neighbor in the back saw everything. She was up there with her phone. He motioned like he was going to kick me in my face. He just ragdogged me everywhere. And I said, if you don't stop, I'm going to call the cops. He's like, call him. I got money. I'll bail myself out. So I called him. They came. They arrested him for the video that he showed. the officer came in and said, we're arresting him for the video that he showed because we believe he was the aggressor. So if I was this bad person, I didn't want to leave him alone, then why did I ended up in the ER from him hurting my neck from handling me. So if I was the aggressor and he didn't want nothing to do with me, then why was he calling me from jail, apologizing, taking accountability for stringing me on, for lying to me, for doing all these things? Why did I pick him up from jail, right? That night I took him home. We went and had dinner after he got out of jail. I dropped him back off at home. I came home. I refused to answer his calls. He showed up at my place. So Ronnie is quite the opposite because he has this toxic relationship with every woman that he's with. So if I'm this person, then why does he keep showing up? I don't beg him to be with me. I move on with my life. He shows up. So, and for the court case that happened back in September where it got dismissed, I wrote the prosecutor and asked him to please not go forward with the case. I was working with a victim advocate through that. So, and then to the incident that happened when we were at an establishment and we got in my car, that month prior, he had already put his hands on me. He was threatening to slap the shit out of me. Listen, Ronnie will come off as he's, this secure man. He's not. He's very jealous. And so we started tussling in my car. I also have voicemails because he's infatuated with phones and things like that. And so he was calling my phone, and I have that voicemail. And I could have submitted that, and I still can, of him that night, October 5th. So the things that he's saying is quite opposite. We talked to each other mutually through WhatsApp. I submitted a video where he was calling me from my home through Alexa. And now all of this makes sense to me because he was telling me that his girlfriend, who is there now, was his ex, and he started trial on the 22nd of this month for assaulting her and taking her cell phone and her daughter. So he's telling me that I just need you to stay with me. I need you to be with me. I just need to get through this court case. I don't want to be with her. I should have never messed with the girl in Bremerton where my life was, and all of these things, right? So what Ronnie's doing is playing both sides here. And so he can't have it both ways. So back in April, I was fed up because I just felt like things were shifting. He was lying to me. And I said, listen, if you choose to go be with her, go be with her. Leave me alone, right? He's the one that keeps coming back. So it's really disheartening for him to sit up here and say these things because this is the opposite. He's like, no. I said, well, maybe we can reconcile after your court case. This is really hard for me to handle, knowing that you have to be a part of her life when you want me to be a part of yours. I said, let's just pause this. He's like, no, because I know I'll lose you, this and that and this and that. So back on April 12th, something came up and we were arguing about something, and I threatened to call her and say, I'm just going to tell her that I'm in the picture and all of these things. And he became so irate with me that he physically grabbed me. I started recording, which I have video of that. And I think I submitted it to your court, but I also submitted it to Superior Court because we have a court case on Friday. So all of these things, I started documenting all of this stuff with him because I knew that Ronnie does not know how to tell the truth.
Okay, can you stop? Did you say you have a court case in Superior Court also?
So it's a restraining order, and Lacey PD has been trying to
court. You have a court case in Superior Court.
So not a court case. We have a no contact order, right? So a restraining order.
Can you let me answer my question, ma'am?
Yeah, go ahead. Sorry, it's cutting out.
Are you asking for an order against him?
No, I got one out of Pierce County in Superior Court. Lacey PD
Mr. Jackson.
Against Mr. Jackson, yes. So Lacey PD, the judge ordered Lacey PD to serve the restraining order. Lacey PD has been unable to contact Ronnie. He refuses to call them back. So I'm asking the court today why he's there, if he can please be served, because our court date for that is this Friday, the 30th.
Did you know that?
Yeah, I talked to the officer and I told them that I would be here today at court. I have the voicemail. I talked to her. I told her I would be here today at court. And I told her also that Ms. Ringener was retaliating because I filed for a protection order. Yes, I did talk to them.
Okay.
Judge, and the other thing is I also filed charges on Ronnie for the assault that happened April 12th and April 20th out of Lakewood. I live out of Lakewood, so it goes to the Lakewood courts. So that's in the process with the prosecutors. And actually the officer that took the original report met with me again last week for an hour and got additional information from, so at some point he's going to face charges for those 2 assaults here out of Lakewood. As far as retaliating against him with the restraining order, I let Ronnie know that I was down at at Pierce County Courts putting a restraining order on him. He then went and put one on me. So I don't force Ronnie to be with me. I don't do any of these things. He plays between the 2 women, the 3 women, the 4 women, however many women he has. And he plays victim to this. I don't own a firearm. And even if I did, I would never brandish it or be malicious about it. The only person that has used a weapon against someone is Mr. Jackson, who shot someone and was charged with first-degree murder, found guilty, spent 23 years in prison. And he's only been out 5 years, and he's already put his hands on 4 women since he's been out. He has zero accountability for what he causes and creates. So I don't go beg Ronnie to be with me. He shows up at my home, 1 o'clock in the morning, 3 o'clock in the morning, 5 o'clock in the morning, shows up at my office, all of these things. So it's really disheartening to stay here, but I knew that Ronnie was going to come in and spin a narrative to fit him. And that's okay, because whichever way you decide today, Your Honor, I will abide by that. It doesn't affect me if this is on me. It's just another way of him trying to control me if we run into each other or something like that, because Ronnie is super vindictive. And he's already told me that if I crossed him and I put what he's built since he's been out with his real estate at jeopardy, that I would see that dark side of him. His girlfriend, who's sitting in court with him today, I had a conversation with her the day that, I don't know, probably almost 2 weeks ago, maybe. And I told her that I was filing charges, and she said, Ronnie deserves to sit in jail. And maybe that will give him a chance to think about what he's doing. But she also said to me, be careful, I'm glad it's you and not me, because he knows people. So Ronnie is very calculated. So the real estate and public image that Ronnie, the facade is not who Ronnie is in the background. Ronnie, I believe, is a very undiagnosed narcissistic, but he's also very calculated, to the point where he had an issue with one of his general contractors recently within the last 6 or 7 months. And Ronnie, dressed in all black, found his address because he's a real estate agent, found his address, dressed all in black, and went to his house and was standing in his yard. And he laughed about it. And he was sharing that with one of his real estate buddies like it was cool. But that's just the mindset of him. So if he feels threatened that he's about to be exposed or any of those things, this is what he does. He runs this narrative. I have never begged Ronnie to be a part of my life. He continues to come back. And I'm glad that it's unfortunate that it came to this, but I'm glad at the end of the day that it did, because this nightmare for me is over. I just have to worry about my safety going forward in this court cases and this no contact order on him. I don't have to worry about dealing with any of his women anymore. I don't have to worry about dealing with his manipulation, his gaslighting, any of these things that he does. I'm so thankful that I do not have to be a part of that nightmare anymore. So for Ronnie to sit up here and say all of these things, Ronnie blows up my phone, but more or less Ronnie will show up to wherever I'm at. So he's also threatened to send an intimate video of him and I to my minor child because I wasn't answering his phone, in which I submitted all of that to the court, the text messages and things like that. I also witnessed him punch his girlfriend who's sitting in the court with him today. He's in cases with her in Kitsap County right now, and her daughter. So for him to sit here and try to spin a narrative about I'm this awful person and things like that, that's who Ronnie is. At the end of the day, I know the truth. He knows the truth. He's spinning a narrative to try to save his image. But the image is he's very twisted. He's very cruel. And I'm just glad that I do not have to be a part of this toxicity and all of these things that he has going on in his life. Ronnie's never going to change who he is. His girlfriend that he's with now is going to have to deal with other women. And I feel sorry for those other women that cross paths with him, because they have no idea what is going to happen in their life and what he is going to do. So again, Your Honor, whatever you decide is not going to affect me, because I have no intentions of ever having anything to do with him. He's an abuser mentally, physically, emotionally. and he sees nothing wrong with it, and he gaslights you to justify, I've been in prison for 23 years. This is why I act this way, or I don't take accountability. He's a 50-year-old man, but he takes zero accountability. And so the public image and the private Ronnie are completely, completely different. Is there toxicity in our relationship? Yeah. But you know where the toxicity came from? All of the lies, the cheating, and everything that he's done and created in this relationship. So I don't really have nothing else to add to that. I just want to make sure that he is getting served while he's there, because we do have court on Friday morning in Superior Court for this, for my restraining order. So I'm just asking the courts to please make sure that he is served with his restraining order while he's there today, since Lacey PD was having difficulty getting a hold of him since the 17th.
Okay, so there's a couple things. I'm going to kind of work backwards there. You know, I'm not really, I can tell him when the court date is, but I can't serve him because it wouldn't be appropriate for me to do that. And combined with the fact that I don't have, I don't have the documents to serve him with. I will tell him that there is a court date. Were you aware of that court date?
Yes.
Okay, and what day, what time is it?
I have no idea.
Okay, what day is it?
I believe it's the 30th.
Okay, so ma'am, I just answer the one question. What day and time is your court hearing?
The 30th at 8:30 in the morning.
Okay, so you need to be in Pierce County Superior Court at 8:30 on May 30th. All right.
Okay.
And so I've listened to the testimony, reviewed the file based on, I've heard Mr. Jackson testify. I've heard Ms. Ringner testify. You know, she said the one word that kind of came up is that she had mentioned a couple times, which I tend to agree with, is toxic. And it seems to me like this seems to go both ways. This might be one of those instances where no contact orders are appropriate both ways, where both parties need to stay away from each other. And so, but the only one in front of me right now is Mr. Jackson's petition against Ms. Ringner. I am going to grant the order. It's going to be in place for 1 year. And so, ma'am, you're just not to contact him. And so, which kind of sounds like what you want. And
Absolutely.
Jackson, again, I'm not going to think too much of it. I have no, you know, I'm not following you folks around. I don't know what's happening. I hear one story from here. I hear another from her. But even though you're not part of this order, it wouldn't be a very good look for you to go track her down and make any contact for her if you start to use this offensively, which people do sometimes. You're going to be subject to a court hearing in Pierce County, and if an order is entered there, you'll be expected to comply with it. And like I say, I think it's clear to me that you folks just need to flat stay away from each other. But I'll grant the order here today. You can wait. You can get a copy of it. And then Ms. Ringner, you're free to go. And then, did she provide an email where we can email it?
No.
You have an email where we could send the copy of the order, and you can
Yes,
put it in. Or you can get it off the Thurston County District Court website.
Okay.
And if you want to get it off the District Court website, you're free to go. We'll give you a
All right.
copy of the order now. It'll be in place for 1 year.
Perfect. Thank you.
Sure.
All right, that about wraps up that one. We've got Judge DeSanto, Judge O'Donnell, and we got one more judge. I can't remember his name, but I'll pop him up in a minute. Let's go ahead and do the Judge DeSanto, and then we'll go over to the other judge.
The City of Wyandotte, Robert Allen, 241508. Hey, good morning.
Good morning, Your Honor. Mark Watt on behalf of the defendant, Mr. Robert Allen. Your Honor, there is an oral motion that I'd like to make, actually two.
Okay, just a moment, Mr. Allen.
Robert James Allen.
Okay, so today's the date scheduled for sentencing in this matter. This was adjourned from April 28th. And, counsel?
Just so the court's aware, Your Honor, Mr. Allen did renew his medical marijuana card. He brought it with him. But the motion is, well, the first motion would be Mr. Allen would respectfully request the opportunity to withdraw his plea based on what I believe to be a perception of my ineffectiveness in representing him during the plea negotiations and his acceptance of the plea. He's, without breaking attorney-client privilege, he doesn't believe that I properly advised him. So the first motion would be to allow Mr. Allen the opportunity to withdraw his plea in the interest of justice. If he so chooses, all the witnesses are police witnesses and all the evidence is captured on body cam and video. So I don't think the prosecution will be prejudiced. The second motion.
Well, hold on, before we move to the second motion, I'm not going to even consider an oral motion to withdraw a plea. That all has to be done in writing, so that the prosecutor has an opportunity to respond.
Understood.
Because this plea was taken on March 12th, so now we're over 2 months ago, and I need to be able to review the motion to determine whether or not that is something this court would grant. And counsel, your next motion.
The second motion, Your Honor, would be, since there has been a breakdown in the attorney-client relationship, I would respectfully move to withdraw from the case so Mr. Allen could either secure new counsel or request court-appointed counsel so that they could properly file the motion. I don't know if they want to file a Ginther hearing or anything, or if the prosecution would be in opposition to it.
Okay, and so counsel, when did this all come about?
Well,
did it just come about this morning?
We have been discussing it for a few weeks, and this morning it just came to a head that I can't effectively represent Mr. Allen anymore in line with what he believes to be his best interests as opposed to my conflict with what's happening here.
Okay.
I was retained, and I'm candid with the tribunal, I was retained by a third party who did give me $2,000 to represent Mr. Allen. I proposed that I refund half of that to Mr. Allen at a minimum so that he could.
You refund that to Mr. Allen instead of that to the third party?
To the third party, but basically if they wanted to help him again, I can't in good conscience or refund all of the retainer. I've been down here several times and put quite a bit into this matter so far. So I will be refunding $1,000 to that individual.
Okay, so my question is, counsel, if this was something that was a possibility, why there wasn't a written motion filed before this morning?
I literally believed everything was fine when I was informed of the medical marijuana card, and that it was just the cold feet issues that some of my clients have, and until they give me like clear, unequivocal, I couldn't interpret. I didn't know, you didn't tell me I want to withdraw my plea in any other light than, okay, you're telling me you believe I was ineffective at this point, and what my thoughts were aren't in line with what his beliefs were during these last few weeks. So I do apologize. You're correct that if I knew, I should have filed a written motion, but we discussed it. I said I could withdraw as your attorney, you could find someone else and things like that without getting into the nitty-gritty of it, but it was my belief that the representation was still intact and we were on the same page. And I apologize for interrupting the proceedings earlier, that's when it basically clicked that this is something that I need to bring forth and make these requests.
Okay. Mr. Allen, you have been to court a number of times with Mr. Awada, correct?
Yes.
And you've had opportunity to speak to Mr. Awada on a number of occasions, correct?
Yes.
And you also have had the opportunity to review discovery with Mr. Awada, is that correct?
Yes.
Okay. And Mr. Awada has been your attorney since January, and there's been a number of court dates that have been scheduled. In fact, you all were here April 28th, and we did not hold the sentencing because your client indicated that the CCH was inaccurate based upon what you had represented and requested time to adjourn that to revisit that issue.
And it has been corrected by probation, Your Honor.
Correct. Would that be correct, Mr. Allen?
Yes.
All that is correct, right?
Yes.
Okay. And so now here we are at the date of sentencing, and you want to have a different attorney, and you want to withdraw your plea.
I don't necessarily want a different attorney, but I want to withdraw my plea because I don't feel, first of all, probation ain't even part of the punishment for what I pled guilty to. I took the plea agreement thinking you were going to sentence me accordingly to what the first offense misdemeanor is for.
Okay, so
you're trying to put me on probation, and that's not even part of the punishment.
Pause. What is it that you believe is the punishment for a first offense misdemeanor?
MCL 750, whatever else it says on there, the punishment is only 93 days in jail, $300 maximum fine, community service, a 90-day, 30 to 90-day license suspension, and up to 4 points on your license. I already got the 4 points. I already got the 90-day maximum suspension. I know you're going to charge me the $300 maximum fine. I feel like that's more than enough punishment for a first-time misdemeanor offense. I've never been arrested for anything alcohol-related in my life. I'm 48 years old. Never been in trouble in Wyandotte. You're trying to, the clean slate law is supposed to erase my whole record. You're not even supposed to be bringing up my past record on me. Not the probation department lady already lied on me, put stuff on my record that I wasn't even convicted of, putting 12 to 18 months probation. That's not justifiable for punishment for what I did. What I did is, it doesn't even include probation for the punishment.
Your Honor, Mr. Allen's statements to me was I did not disclose to him that probation was a possible sentence. And those
Probation ain't part of the
Stop
punishment.
interrupting the record, Mr. Allen.
So I want to pull my plea because.
Stop interrupting the record. Your attorney is speaking right now. Just for a moment.
And I do not recall telling him that yes, probation could be part of the court's sentence, or that no, probation wouldn't be part of the sentence. I just assumed that Mr. Allen knew that probation could be part of the court's sentence.
Okay.
So
It's not part of the law.
I understand that, sir. Nevertheless, Your Honor, there has been a breakdown in this relationship, and I can no longer in good faith continue this representation, Mr. Allen, not only for the defendant, protecting the defendant's interests, but also now my own interests, because I'm in a position where I could be looking at a possible grievance if I continue representation at this juncture.
Okay. Mr. Allen.
Yes, ma'am.
So you're telling this court that the matters that you have on your criminal record, that those have all been dismissed?
No, I said I qualified for the clean slate law, and it was my understanding that my past record would not be brought up against me. But here I am, and everything on my record is.
We're gonna take one thing at a time. You understood that you were eligible for the clean slate law. So what does that mean to you?
The lady the representative told me that we went over my record. The CCW on my record, the false report of a misdemeanor, the attempt to receive and concealing, all that was supposed to be erased off my record. It was never supposed to be brought up against me ever again. I was told if I got in trouble again, that none of this would be brought up against me. It would be like I'm getting in trouble again for the first time. So, therefore, the probation lady.
Which convictions are those, sir?
Huh?
Which convictions are those that you're speaking of?
The 7, the false report of a misdemeanor from 2004, and attempted receiving and concealing from like 2012 or whatever, or 2010 or whatever that year was. All of them are more than 10 years ago. You ain't even supposed to be bringing this up against me.
First of all, 2010 isn't on here.
Well, whatever the year was for the attempted receiving and concealing.
Okay, that's not on here, sir.
Okay, so everything else, so there should be nothing on my record.
That's not true. That's not true.
What? There shouldn't be nothing on my record then.
You have a number of criminal convictions, more than just what you spoke of. And the clean slate law, there are certain convictions that are automatically wiped off per the Michigan State Police, from the Michigan State Police per that law.
Yeah.
Sir, the court is looking at.
All right. Michigan's clean slate law, which took effect April 1st, 2023, allows for the automatic expungement of certain eligible criminal records for individuals who have remained crime-free for a specific period. This law aims to help individuals find employment and housing by clearing their criminal records after a waiting period. This guy here in the 90s and 2000s, I don't know that he's ever met the timeline, so we'll get to see what she's got there.
These, and if you
are trying to prosecute me for my past, say it.
Sir, the court doesn't prosecute. Let's clarify that. The court doesn't prosecute. If you are eligible for any of these convictions, sir, to be removed from your record, then you have to follow the steps that have to occur. Right? There's motions to set aside, there's the application to set aside convictions and whatnot. So those are the steps that have to be followed. Some of these are not automatically wiped off.
Can I say something though? I was told since I was a Detroit resident that it does automatically get wiped off. I didn't have to do nothing. The system would automatically update itself. As a Wayne County resident, that's what I was told.
Detroit resident or Wayne County?
Detroit resident, I'm sorry. As a Detroit resident, if the system was supposed to update itself and erase itself, I didn't have to do nothing.
Okay, well, I have to tell you that's the first I've heard of that. I haven't heard that anything is resident specific.
Well, you probably haven't had to go down there and talk to somebody who had your record expunged either.
Sir,
Ma'am,
I'm still given the laws to review when they're passed and then they're enacted. So I don't recall seeing anything about being resident specific. And then why would it be only a benefit of Detroit residents if it's a state statute? So whatever that is, I don't know. I don't know if there's a misunderstanding somewhere. I don't know.
ignorance ain't
How-
an excuse for not knowing the law.
You're correct,
Ain't that
sir.
what you tell me? That's what you would tell me?
Don't presume what I would tell somebody or you. Do not presume that, sir. Now, as well as whether or not probation is something that is a possible consequence, okay? Probation is something that the court would order in lieu. Sir,
Excuse me.
those gestures are not necessary. The gesture of money, money, money.
That's what you
Not
want, right?
necessary. No, probation is something that courts impose in lieu of jail, sir. Now, under MCL 769.5, have you reviewed that one, sir?
No, I haven't.
Okay, well, then I would suggest you review it, because that gives the court judicial discretion if it determines that there is a rebuttal, that the presumption has been rebutted to sentence somebody to probation. Now, if you don't agree to probation, that's your right. And the court also has the right then to impose jail, if that's what the court determines it's going to do. The court also has the right to impose fines and costs only. The court has a lot of judicial discretion, sir, in imposing sentencing. So,
With all due respect, I apologize, Your Honor. I just feel like the recommendation by the probation department is way too harsh for a first-time misdemeanor offense. That's all I'm saying.
okay, and
If
sir,
you
you
want
have
to
the
punish
right
me
to
for
have, sir, you have the right to have that opinion.
I understand that, Your Honor. I apologize. I'm not trying to be disrespectful. I just don't agree with the punishment for the crime. That's all. If you put me on probation, I feel like you're setting me up for failure. That's
And
all.
why is that?
Because first of all, I'm on SSI. My $900 a month is gone before I get it. I don't have no thousands of dollars to give you. My license has been suspended
Let's
for
clarify, you're
90
not
days.
giving it to me, sir. Let's clarify, you're not giving me money.
But I'm saying I don't have any money to give anybody, is what I'm saying. The 90 days, my license has been suspended for the maximum 90 days. I haven't seen my granddaughter, my goddaughter, or my kids in over 30 days. I'm stressed out, I'm sad, I'm depressed, I'm sorry.
Okay, sir, I can understand and appreciate all
I
of
feel
that.
like
But let me just clarify.
this is my first time.
Let me clarify,
I
sir.
feel like this is more punishment.
This court does not suspend your license. The Secretary of State did that.
I understand it, but it's still a punishment, a part of the law of the punishment. And I've gone through that punishment. And now I'm hurting because I can't see my own kids now.
And why can't you see them?
Because my license are suspended.
They can't come to see you?
My son don't have a car. You know what I'm saying? My daughter, she goes to nursing school. She's a full-time mother
Okay, so where does your daughter live?
in Woodhaven.
Okay, and you reside,
I live in Detroit, and it costs a lot of money to take an Uber back and forth that I don't have the money for.
okay, what a bicycle? What about a bicycle? What about somebody
I'm
else?
disabled. I'm gonna ride a bike from Detroit to Woodhaven.
Sir,
You're asking me, man, this is ridiculous, man.
I'm just asking options.
Can I just get a fine and go about my way, man?
And sir,
You're trying to punish me too much for a first-time misdemeanor offense. I've never been arrested for anything alcohol-related. This is a 90-day misdemeanor. You're talking 12 to 18 months probation. That doesn't fit the punishment of the crime, man. That's too harsh. Even with the criminal record that I have, 12 to 18 months probation is too harsh. I haven't committed any crime. I haven't been convicted of anything in more than 15 years. This is a first-time misdemeanor offense. It should be a fine and my license suspended and have a nice day, sir. If I come back here again 2 or 3 times to keep drinking and driving, yeah, then I can see getting 90 days and all these probation and all this. But this is a first-time misdemeanor offense. I feel like you're being way too harsh on me.
sir, I haven't assessed anything at this point.
But I already know what you're gonna do. I sat in your courtroom and watched you sentence 10 people. And ain't nobody walked out of here with under $2,000 in fines, all kind of probation and everything, bro, for misdemeanors.
Okay.
This guy just got all this for all these probations and 2 years probation and he did assault and all this and you're trying to give me 12 to 18 months probation for a simple misdemeanor?
Sir, first of all, your,
How could they even recommend that, bro?
your conviction is eligible for early discharge. So if you wanted to start comparing the
It's
cases,
not eligible.
stop interrupting me. Stop interrupting me. If you want to compare cases, then you need to have all the facts. You don't know all the facts on every case. This court takes every case, every individual that comes before it, and reviews the report, the recommendation, criminal history, what other special circumstances there are before this court fashions a sentence. Now, it may seem from your perspective that they're very similar because some circumstances, right, some offenses benefit from similar rehabilitative conditions.
It's a simple misdemeanor charge, man.
That's your opinion, sir. That's fine.
Blown out of proportion. That's all I'm saying.
Well, sir,
If I
you
come
also
back 2 or
have,
3
you
times
also
a
have the
year-
option of after you consume the beers to have somebody else drive you home, then you wouldn't be here.
You're right. And I really want to go to trial because making me blow 13 breath flies and charging me with something that with only one, you notice, I was falsely arrested anyways. I was falsely arrested. Officer told me, I don't like how you're talking to me. If you don't quiet down, I'll take you to jail for disorderly conduct. That's not disorderly conduct.
Stop, you're not, I'm gonna.
I want to
yeah,
withdraw my
sir,
plea and go to
sir,
trial.
Sir, stop talking, please. Stop talking. The court's going to grant Mr. Awada's motion to withdraw based on the breakdown of the attorney-client relationship as far as the direction of resolution. It appears that there's a clear difference of opinion. Mr. Allen, are you intending to retain
Oh, yes,
other counsel?
I'm gonna hire another lawyer. Somebody that's gonna fight for me. I took this plea to be cool, you know? I wanted to go to trial the whole time. I
Sir,
took the plea
you don't need to
under
keep
my
talking.
lawyers.
Stop
Okay,
talking.
I'm just
Stop
saying.
talking. As of now, this is still scheduled for sentencing until this court receives a written motion regarding a plea withdrawn. So, sir, when whoever it is that you're going to be speaking to and retaining, when your attorney sees that on the docket it's scheduled for sentencing, that's because that is what's currently on the docket for procedurally. There's not been a written motion to withdraw the plea. This court's not going to entertain an oral motion because the prosecutor has an opportunity, has to have an opportunity to review the motion and file a response. So we'll adjourn the sentencing.
So I'm not gonna be able to pull my plea and go to trial? I'm just gonna be able to hire another lawyer for sentencing? Or am I gonna be able to?
Sir, do you listen to what's being said, or you just listen, wanting to say what you gotta say?
I'm listening to you.
What else?
I'm asking for clarification.
What I said, sir, was that it's going to be scheduled for sentencing, because that's what's currently procedurally scheduled.
I
There is
understand that
not,
part.
there has not been a written motion received by this court yet.
Okay.
So once there's a written motion, it will be set for a motion date.
Oh,
But as of now, this court's not just going to set it for a motion date because I have no idea who you're going to retain and what that attorney's strategy is going to be.
Thank you, Your Honor. I just wanted clarification. I'm sorry. I apologize.
You will adjourn sentencing to be June 18th at 9:30 a.m. That's a Wednesday. And I did that so that in the event your attorney files a motion to withdraw the plea, it will be set on a date that's a wind-down date. So then that will be a motion hearing date. Now, sir, I'm sure Mr. Avada is going to tell you that there's procedure for motions. Notice has to be given so that you need to retain an attorney sooner than later. If you're in a test right now, sir, what's in your system?
Just marijuana, Your Honor, like always.
When did you obtain this medical marijuana card, sir?
I went and got it like probably 10 days ago.
Okay, and so did your treating physician give you any documentation to?
My primary caregiver, she retired, Your Honor, so.
No, sir. I
Yes,
asked
she
you your
did.
primary caregiver.
I mean, not primary caregiver, I mean, my primary care physician, my primary doctor that I used to go see,
Okay.
Wendy McKay, she retired, so I don't have no way of like going in and talking to her anymore or nothing, so.
Okay, when did
I
she
would have a couple
retire?
years ago.
Okay, so who have you seen in the meantime?
I haven't seen nobody because they send me, the new doctor that they assigned me was way out on 14 Mile and something, and I didn't need to go to the doctor since then, so I just never been out there.
Well, sir, the court does not accept a marijuana card from a marijuana clinic. The court indicated that the court already indicated what the requirements
I
were.
told you a doctor, you can't go into your doctor and say, hey, doctor, can you write me a letter saying you feel like I need to be on weed? Doctors don't do that. You can't do that.
That's incorrect, sir.
I don't know what doctor you talk to, but they don't do that.
Sir, I'm not.
I asked my doctor before.
I told you what the.
That's why I got the card.
Sir.
They don't do that.
Well, you know what? Then we're gonna have to hold a hearing on your card and whether or not that doctor's going to come in to see how long.
Let's handle this first, okay?
I'm sorry?
Let's get let me hire the new lawyer. Let's go get this because we can argue about that later, man.
Well, in the meantime, sir, you're probably going to be coming back for a bond violation.
Yeah, okay. I didn't violate my bond. What are you talking about?
Sir, you're using marijuana. That's in violation of your bond conditions right now.
You told
And
me
once you've been under the jurisdiction of this court, the requirements for medical marijuana are clear.
You know I'm using it for medical reasons. You see my paperwork, Your Honor. Why are you doing this? This is what I'm talking
Sir, if you have
about.
medical reasons, then you would have a doctor that you are treating with that would determine whether or not the medication is appropriate. I'm not going to argue with this any further. If you're testing and you're testing positive for marijuana, then we'll have a bond violation. All right, bonding conditions are continued. Thank you. Have a good day.
Thank you, Your Honor.
Well, that worked out good for him. I'm kind of curious. That type of case right there would be the great one to see the body camera video from the police on that one. I'm sure he was just as calm as relaxed as could be, and it was just the police that were all over the place and the police that were being inappropriate with him. He seems like a good guy to me. All right, we're going to jump into another. Let's jump into another court.
Kendrick Richardson.
Good morning, sir.
Mr. Richardson, you're charged with 2 counts of assault. You're facing up to a year in jail and or a $4,000 fine on each of your cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On August 31st, 2024, an officer was dispatched to an assault at the V-Live Club at 6603 Harwood Drive, Harris County, Texas. The officer observed the complainant and the defendant that had moved to across the street in an open parking lot at 6440 Southwest Freeway in Harris County, Texas. The complainants were yelling for help and several males surrounded the defendant. One of the complainants stated that she and her friends were in the club. She observed the defendant, a stranger, touching and pulling on her friend, another complainant. The first complainant observed her friend scoot away from the defendant. The defendant continued to approach the second complainant and continued to touch her body. The second complainant once again moved away. The first complainant grabbed the second complainant and physically moved her away from the defendant to show him his presence or company was not wanted. The defendant used his hand to grab the second complainant's face and cheek area, pulling her towards him. The second complainant threw a punch at the defendant. The defendant threw her to the ground and punched her several times with a closed fist. The first complainant began to fight the defendant to protect the second complainant. The defendant struck the first complainant several times all over with a closed fist, causing pain. While the first complainant was trying to explain to security what happened, the defendant punched her in the face with a closed fist, making contact with her jaw, causing pain. The first complainant became lightheaded and felt dizzy. The second complainant stated that she was in the club with her friends. The defendant, who was a stranger to the complainants, approached her and began to touch her thigh and leg area. The second complainant stated that she moved away from the defendant. He touched her again and brushed the bottom of her breast. She moved away from the defendant once again. The defendant then grabbed her by her face and cheek, and she punched the defendant once. The defendant grabbed her by the hair and threw her to the ground, ripping her weave from her hair, causing pain. The defendant then began to strike her several times in the face with a closed fist, causing pain. The second complainant stated that she fought the defendant back while she was on the ground. Officers observed injuries on the second complainant's face, spots of red blush/bruising the size of a nickel, a red mark approximately 4 inches long on her shoulder blade, consistent with being thrown to the ground. The defendant stated that nothing happened and he just needed to go home.
Mr. Richardson, I'm going to find that there's probable cause to go forward on each of your cases. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm also ordering you as a condition of your bond not to go to any nightclubs, bars. More than 50% alcohol sales are done. Do you understand?
Sir.
If I find that you violate these conditions, I'm going to put you in jail. And I'm going to tell you now, I'm going to make your bond so high that you're just going to spontaneously combust. I will do everything in my power to protect every single person of Harris County. Do you understand?
Sir.
No contact with either of these people, no weapons as well. Do you understand?
Sir.
What do you do for a living?
Box.
Say that again.
Box.
You're a boxer.
Yes.
Holy moly. So are these deadly weapons then? Because if they allege it deadly weapons, guess who gets a serious second-degree felony? You're looking at 2 to 20 of the penitentiary on that one, on each of those. You better be careful, Mr. Richardson. Do you understand?
Yes, sir.
What kind of income you make with being a boxer?
Well, I've just started.
You just started. So how do you make money? Where do you work?
He just works beating women, I guess.
I work at the port.
He looks like he's been hit a few times.
What kind of income you make working at the Port of Houston?
Around 10. I just started, so I'm trying to get back into the
Everybody's just starting.
Into the flow of work.
Why'd you stop?
My TWIC card. I had lost my TWIC card.
For anyone who doesn't know, a TWIC card is transportation workers information card, ID card. Anytime you're going to work at a port or something like that, you gotta have a TWIC card to get on site. And if you don't have it, you're not getting on site. I know. When I got mine, it took a couple of months to get it because they got to do a background check on you and also. So if he had a TWIC card, he's not a terrorist. At least he may be an idiot, may be hitting women, but he's certainly not a terrorist.
Are you on probation or parole right now?
Yes.
Which one? Are you on parole?
Probation.
Where?
Children's County.
Can you run his NCIC, please?
See you later, CJ.
Is he on probation anywhere else? And what for?
Your Honor, he's not on parole. He's completed his confinement to the robbery. With regards to Childress County, he's on a 4-year probation for harassment started in 2023. That's when he left.
Better be careful, Mr. Richardson. You need a lawyer. One, that county figures out you've picked up with 2 assault cases here. You know what's going to happen, right? They're going to issue 2 new warrants for your arrest. For those, or at least one issue, they will issue 1 warrant for your arrest for the probation that you're on in that county. You're supposed to behave yourself while you're on probation. And when you don't, warrants issue. You want to apply for an appointed lawyer, sir? I'm absolutely serious when I mean protecting the public, Mr. Ritson. I'm going to do everything in my power. You start acting a fool in the free world, I'm going to take the free world away from you. Do you understand?
Yes, sir.
All right. Come on.
Just wait a second. Mr. Richardson. Hold on. She's going to have you sign for a reset over here.
All right, guys. I got a question for you on the little poll question. So the lives we're doing during the weekday, you guys got to let us know what you think about that. Let us know if you want us to continue doing it and what judges you like, what judges you don't like. I'm boring. I can sit and watch a city council meeting for 4 hours, but we want to do something that's entertaining for you guys. So you got to make sure to communicate what you want. Make sure to let us know. Let any of the mods know that they're great at communicating, and so they'll let me know which direction we need to go. We've got one more video for you, Judge O. Critter, you asking how long ago was this? At least 24 hours ago. This video was at least 24 hours ago. I got to go back and look on the date, but it wasn't today, and I'm almost certain it wasn't yesterday. So I'll figure it out for you, Critter.
Cuts.
Thank you, Your Honor. We are here today in 4 separate cases entitled State of Ohio versus Crystal Facemeyer. Your Honor, we're here today on probation violations on the 2019, 2020, and 2024 case. The defendant previously waived probable cause, states understanding that today she will waive final hearing and plead guilty to the violations and proceed to sentencing. We're also here for sentencing on the 2025 case where she pled guilty by way of information on May 7th of 2025 to 1 count of theft of drugs of felony of the 3rd degree and 1 count of theft of felony of the 5th degree. At that time, an updated pre-sentence report and victim impact statements were ordered. The state's understanding the updated pre-sentence report was completed and provided to the court, and that all parties are prepared to go to sentencing at this time.
The violation in the 25 case, is it because of the conviction in the sentencing in the 24 case?
There is, because that's just
Okay.
a sentencing, but it is one of the bases for the violations in the 24, 2020, and 2019.
All right, so she's already pled guilty in the 19 and the 20.
That's from a prior probation violation.
All right, I'm not even going to monkey around with that. Okay, we're going forward on the 25 case. Is there a violation filed in the 24 case?
Yes.
What's the violation?
The violation in the 24 case is 1, 2, 3, 4 violations of Rule 1.
What's Rule 1? Don't give me these rule numbers. Just give me what the violations
all
are.
local, state, and federal law. So it's all of the new charges.
I know. For what charge? For the 25 case?
Yes. So for the original charges stemming out of Willoughby Municipal Court, 25 CRA.
So you have a violation in the 24 case for the criminal nature of the 25 case. Okay, that's all I'm doing.
There's other additional violations.
I don't care about that. I don't care. Okay, we can sit here all afternoon and go through all these things if we want, or we can get on with the business. So in the 24 case, there's a violation for criminal activity that resulted in the 25 case. Is that correct, Mr. Cherry?
That is correct, Your Honor.
How does she want to proceed on that?
Your Honor, I've had an opportunity to discuss this with my client, and we're prepared to waive final hearing and enter admission at this time.
Is that what you want to do, Ms. Facemeyer?
Yes, Your Honor.
So on the 24 case, what is your plea to the violations which came as a result of the criminal activity in the 25 case?
Guilty, Your Honor.
All right, I'll accept your guilty plea and find you guilty. Now, Let's go forward on the sentencing on the 3 probation violations and the 25 case. Mr. Cherry?
Thank you, Your Honor. Your Honor, this is definitely not how I was envisioning being in front of you next time on this case. As I recall, I'm disappointed, even myself, that we left here on a positive note with an opportunity for treatment, and we're here back again on a new case, a new charge. All I can say is that I've been involved with people that have been recovering from addiction of various kinds and various stages for a long time now. And I've seen some people get it right away and work the program and become better and stable, and other people struggle over and over and over again. Come to believe that relapse is part of the road sometimes of recovery. And it's an unfortunate road for...
You know, I got to hear that about my kid that relapses on the road to recovery, and I just don't know that I can believe that. I just don't know that, you know, to me, I felt like we were giving my kid an example, you know, an opportunity for, hey, you get 2 get out of jail free cards, and I don't know that I buy that, but I'm not the one that's addicted, so who knows?
It's a fortunate thing to understand for people who are outside, who don't experience what it's like to be subject to an addiction. Ms. Facemeyer has addressed and still struggles with, and will always struggle with, her substance addiction. Nevertheless, she had largely been in remission prior to maybe what happened when she was taken into jail with positive. Beyond that, she had 3.5 years after you put her out on judicial release before she got back in the system. She has been able to put together a long period of sober time. This addiction is a replacement addiction. It's the same thing that happens in your brain, no matter what your drug or activity of choice is. It triggers your endorphins, it makes you excited. Your reward center lights up. That has now happened for Crystal Facemeyer with gambling, what used to be for drugs. It's nothing different. It's just a new flavor of the same problem she's had. And I know you've worked with her for a long time and given her plenty of treatment opportunities. I would just ask this court to consider NeoCap again. The last time she was there was in 2016. NeoCap is a program that is designed to address criminal behaviors and is a program that can handle a gambling addiction along with whatever might remain of her drug addiction, and get her back on the path to where she is able to be honest with herself. One of the things that was mentioned by the prosecution in chambers is that her honesty is an issue. Well, of course it is. She's an addict. Addicts are by nature dishonest. They have to do whatever they can do to maintain their addictive lifestyle. I'm just asking you, whatever you do for her sentence, that you consider treatment to be a significant and primary part of it, so that we don't just throw Crystal Facemeyer away. We give her at least the tools available to her that she can recover. And I'm asking this court to issue a NeoCap order, the jail treatment program, and an opportunity to come back before you in, say, a year for a judicial release hearing and possible probation with IOP. Thank you.
Thank you. Ms. Facemeyer, what do you want to tell me?
Your Honor, I just want to take full responsibility for my actions this time. I understand I've been in front of you a lot of times, and this time, though, I stand before you just asking for a last chance at mercy, because I do finally have a life that you gave me when you gave me judicial release that I don't want to lose. I'm here because you granted me that chance to even go into treatment and save my life that first time, and I'm just asking for it one more time, Your Honor, please. Thank you.
Your Honor, I apologize, but I failed to ask you earlier. My client's boyfriend, Dan Blankshain, would like to be heard, and Pastor Rollins is here as well. You heard from them before.
Okay, just tell me, just state your name and tell me whatever it is you want me to know.
Your Honor, my name is Daniel, and I'm Crystal's boyfriend. I acknowledge the fact that her actions and her choices alone are the reason that we are here today. I met Crystal in the program of Alcoholics Anonymous several years ago. We were members of the same home group. We both held various service positions in the group. As I got to know her a little bit more, I learned about her struggles and her journey. I had the chance to hear her story at a meeting the first time that she gave it publicly, and it gave me a lot of hope at a time where I was dealing with a lot of personal issues. And it gave me that hope that if I kept applying myself and I kept applying the principles of the AA program, that I'd be able to overcome my circumstances and maintain my sobriety, which by God's grace I have for over 7 years. Since that time, Crystal and I have gotten to know each other very well. She came to live with me in January of 2024. We continue to attend AA meetings both together and separately. We attend St. John Nottingham Lutheran Church together nearly every Sunday. We pray together both in the morning and at night daily. Crystal has made my house feel like a home again. She's contributed more than just helping me by cooking, cleaning, and helping with bills. She's encouraged me when I've doubted. She supported me when work has been overwhelming, and she selflessly helped her 22-year-old nephew out with money for car repairs and helping him tie up loose ends, while she's received no emotional or financial support from her own mother or father or anyone else in her family. She's been a strength and supportive to my elderly parents who themselves have significant medical issues, offering her knowledge and certain things dating back to her experience as a registered nurse. She's been a true blessing to me and for them. I love her beyond words because I can't put into words what her presence in my and my family's life has meant. I've done everything that I can to repay that kindness and support in spite of these present circumstances. That's why I stand here today asking you for your mercy. I know that Crystal has brought a great deal of hardship upon herself. I know that every avenue has been explored and tried. It has not all gone in vain. Though her progress has been slow and has not satisfied this court entirely to this point, I have seen growth. As a recovering alcoholic and addict myself, I know firsthand not only the potential for legal consequences for those who suffer from this disease and the choices that they make, but most frightening is the potential that any day, any time an alcoholic or addict of any sort of vice chooses to drink, the drug, or even something like gambling over sobriety, it could be their last. Crystal chose to accept treatment when it was ordered to her and abstained and remained free from the grips of drugs for over 5 years until these present circumstances. Each addict progresses at a different pace, and once we cross that line, everything has the potential to be just as dangerous and destructive regardless of the form that it comes in. Crystal has come to that same realization and asked me to begin looking for facilities that would accept her on an inpatient basis the same day that she was arrested. I firmly believe that she has finally reached bottom and is willing to address these demons fully once and for all, but she needs that opportunity and a little extra grace in order to be able to do it. I've made several calls and tried to find somewhere that would accept her on an inpatient basis for gambling, but there is none that's been available. She has had 2 assessments that were conducted, one in Geauga County, and they are unable to accept her. However, there is Signature Health, which is where she receives her psychiatric help from, which does have a gambling-oriented IOP program, as well as individual gambling counselors licensed and certified in that area of recovery. Your Honor, I understand that punishment is part of justice, but I humbly believe that restorative justice should also include the restoration of the offender. Part of that restoration and recovery from addiction is establishing a relationship with a higher power, who Crystal and I both know as our Lord and Savior, Jesus Christ. Crystal is still a young woman who has shown potential in the past. She fell into a long, dark, and troublesome path and has struggled mightily to free herself, and it hasn't been for lack of effort. Addiction is a cunning, baffling, and powerful disease. It leads people like her and I and countless others down the road to ruin, but it doesn't have to be a death sentence for us. We do recover if we're willing and we're able, and when I see her, I see through the years of the struggles that she's endured, the look of defeat, the emotional toll it's taken on her. I see the woman who still has hope, who still is holding on to her faith, and who just needs a little bit of extra help so that she can live a full and productive life. One that can make us all proud. It's never too late while we're on this earth to make the changes that we want to make within ourselves. It is my prayer that you will consider this and that you will grant her that opportunity. Thank you.
Thank you.
Ronald Rollins, I'm associate pastor at St. John Nottingham, where both Crystal and Dan attend. I'm here to support her. As long as she's been incarcerated, I've continued to visit her and pray with her and to help her understand that she's not abandoned. My concern is that she feels alone. She knows that our Lord is with her, but this is a difficult time for her, I understand. But I'm here purely out of support for her and to seek the mercy of the court for her.
Thank you. Ms. Cutts?
Thank you, Your Honor. I won't go through every detail. I know this court is familiar with these cases, but I do feel I need to do a level of information for the record. So in this most recent case in 2025, defendant was going into people's cars that were in parking lots. She was checking which doors were open. When they were open, she was going in and taking anything out that apparently to get money of some sort. She was at 2 different locations on March 17th for the most recent case. One was a business. One of the employees, Tammy Orr, went out to her car early in the morning. Her items were, including her purse, were in there with her medications, her money for bills, and some shopping money. Then when she went back out around the lunchtime hour, she realized her purse was not there. It included IDs, credit cards, 4 prescription medications, and approximately $180 in cash. When I spoke with her, she indicated that once she found out and was able to see the video of a person going into her car, she felt very dirty and had to wash her car inside out. She felt very violated. She said she had $120 set aside for bills that she had looked through, and between $60 and $80 in cash for some shopping she was going to do. Mr. Butler was working. He's the other victim. His company was at a location when he left his work vehicle unlocked as he was going in between the building, and his metal folder full of receipts was taken and a bag full of checks was taken. So they both had economic harm. We'll say that Mr. Butler did get all of the items back, but at the time he was concerned for his work aspects. Ms. Orr got everything back except for the cash. That's because when the police thankfully were able to locate the defendant quickly, most of the items were still in her possession. These new offenses were committed while she was on community control in the 3 other cases we've mentioned. In the 2019 case and the 2020 case, she was on judicial release, so she had previously been to prison. And then in the 2024 case, she was on probation. She does have a history of criminal convictions. The majority of them have gone through this court. So we have the 2016 case where she was convicted of 10 counts of illegal processing of drug documents found in the 4th degree and 10 counts of forgery found in the 5th degree. She was given treatment opportunities at that time, as been mentioned, NeoCap and as well as JTP and Oak House. She did have multiple probation violations in that case, which included testing positive, being discharged from aftercare, bringing in somebody else's urine. She was ordered to Oak House and Opiate Recovery Program. Then she had new charges out of the Mentor Municipal Court, which later became her 2019 convictions for possession of drugs, a misdemeanor, and petty theft. When probation was trying to work with her for review hearings, she failed to appear. She didn't bring documents as requested, and then additional charges came through. And she also tested positive for fentanyl and opiates. She was then revoked and sent to prison. That prison sentence was completed prior to the judicial release. But in 2019, as I mentioned, she had the misdemeanor theft and possession of drugs. In 2020, she was convicted of trespass and habitation when a person is present or likely to be present, found in the 4th degree. Also in 2020, she had a separate case of burglary, found in the 3rd degree, and identity fraud, found in the 5th degree. In 2025, she has the theft, felony 4, and identity fraud, felony 5. So, thank you.
All right, I've reviewed the pre-sentence report and the record for the previous cases. I've considered what Ms. Facemeyer has had to say, what those in support have had to say, what counsel has had to say. I've considered all the provisions in 29, 29, 11, 12, and 13. So this, in our history together, this is case number 5. One of them is done, the 16 case. The others, you've been given opportunity after opportunity after opportunity for treatment. And then this last case doesn't involve something as damaging yet innocuous as a failed drug test. It involves going into other people's property and stealing from them, taking the opportunity on numerous occasions and breaking into people's property. So based on the totality of the history here, I'm going to find you're no longer amenable to community control. On 25-368, on count 1, I'm going to sentence you to 30 months in prison. On count 2, 12 months in prison with credit for 24 days, restitution to or in the amount of $180. On the 24 case, on count 1, I'm going to sentence you to 12 months in prison. Count 2, 12 months in prison, credit for 1 day. On the 20 case, I'm going to sentence you to a term of 18 months in prison with credit for 78 days. And on the 19 case, count 1, 18 months in prison. Count 2, 12 months in prison. Each of the multiple counts in the 19 case, the 24 case, and the 25 case will be concurrent to each other, and each of the cases will be concurrent to one another. Costs are assessed on each of the individual cases. When you get out, you might be on post-release control for up to 2 years under the parole authority. If you are placed on post-release control, they will impose conditions upon you. If you violate the conditions, they could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, then you could get an additional consecutive prison sentence for the violation, a maximum of which is the greater of 12 months or the time left under post-release control. Is there anything further, Ms. Cutts?
Yes, Your Honor. Some of it may have been what I missed. The 2019 case, she was originally sentenced to 36 months on count 1
Right.
and 6 months on count 2, so that would need to be reimposed as it was.
All right, I'll give her 6 months on count 2, 18 months on count 1.
I have a brief moment, Your Honor. I believe that's all, Your Honor.
Mr. Chair, anything further?
Just a couple of brief things. One, Your Honor, I know we filed a motion for the administration of gabapentin, and I know that was denied. There is also an issue with Lamictal and Zoloft, as I understand it. My client isn't getting it as she's prescribed. Could that be addressed? It was my understanding that was brought up at the prior hearing, but I wasn't here. No?
It was not. I'm not.
No, it started to be brought up in chambers, and you had indicated that you had dealt with that and that it would have to come up later. And
All right,
But
so
you would ask for
that,
paperwork.
that motion was filed, right?
The gabapentin motion was filed.
Okay,
yes.
I'll have to take a look at it, because there are certain drugs they will not administer in the jail. Yeah.
Oh, I'll tell you, I found gabapentin on that list.
Okay,
I'm not going to lie about it, but I filed the motion because she has prescribed it.
okay.
And I'm not sure about Lamictal or Zoloft, if they're
All
on
right.
the list or
I
not.
will take a look at the motion, we know you filed it, but we didn't address it, so I'll have to take a look at it.
Was there a new motion filed? Because the first motion filed was denied.
Yes, that is correct. I could renew the motion with the additional drugs just for your reference. Do whatever you like.
All right, yeah, go ahead and do that.
Okay.
Okay.
And may I have a moment for her to execute
Yep.
a car title before she's taken?
Yeah.
That's all.
All right, guys, that's the end of that one. Thank you guys so much for coming out. We're gonna try to do another one tomorrow night. Yeah, we're gonna try to do that. Trying to pull up the ending credits. We hadn't done that in so long. Thank you guys for coming out. We'll see you guys tomorrow night. Thank you.
please.